Welcome back to another episode of Stork Talks.
I'm Zoe.
And I'm Tom.
This week on Stork Talks, we focus on corporate responsibility. Are we entering a new era in which multinationals like Shell will be held directly responsible for climate change, and a global minimum corporate tax will mean tax havens are less easily found?
Now, both of these issues are relevant to the Netherlands, where earlier this month a Dutch court handed down a historic ruling against the Royal Dutch Shell Company, stating that it must reduce its CO2 emissions by a net of 45% by 2030, regardless of the actions or policies of the Dutch government. And this climate ruling is the first ever worldwide to impose a clear and measurable emissions reduction target on a company and its value chain.
Yes, I think this is really a very interesting case, Tom. And the verdict is based largely on international climate law in the form of soft law standards from the UN Guiding Principles on Business and Human Rights and the OECD guidelines for multinational enterprises. It also links climate change directly to human rights. Now, Shell will appeal the decision and might even win, but a new standard has definitely been raised and a new precedent set.
Indeed, corporations have also been coming under pressure with regards to the tax they pay, or apparently the tax they don't pay. If these stats are accurate, in the last 50 years, corporate tax rates have dropped. Yes, dropped by 50%. And at a recent meeting of the G7, serious discussions were had regarding a possible minimum global corporate tax rate. And figures of 13, 15, and 21% were suggested. But will this measure really prevent the so-called race to the bottom and ensure the equality that we seek? And to answer all of these questions and this topic, we would love to welcome Joseph Wilder Ramsing on our show today. Welcome, Joseph.
Thank you very much for having me, Tom and Zoe.
Now, Joseph is a senior researcher at the Center for Research on Multinational Corporations, also known as SOMO. Welcome to Stork Talks. Perhaps we can start, Joseph, with this idea that this recent judgment affirms that companies, to quote, I think from one of your blogs, affirms that companies of all sizes at all times have an individual responsibility to prevent human rights violations and environmental damage in their operations and their entire value chain, and a failure to do so can be considered an unlawful act. Now, this sounds really extensive. Can one realistically hold multinationals responsible for entire supply chains?
Well, the court has obviously said yes, and this is something that, in fact, is really not new in the world of corporate accountability. And you mentioned earlier the UN Guiding Principles on Business and Human Rights and the OECD guidelines for multinational enterprises. These are two pieces of international soft law that have been around really for a decade now. And both of them are very clear that corporations have a responsibility to prevent negative impacts on people and the environment, not only in their own operations, not only in their own factories or at their own mines, but also in their entire value chain. What the case is, though, that there is a difference in expectation of action for these different types of abuses in the supply chain versus in your own operations. You cannot expect a company to take the same action to prevent an impact in their own in the supply chain as you can with their own operations, but you certainly can expect them. They have a duty of care, in fact. So you can expect them, and you should expect them, and the court here affirms that it does expect them to take all reasonable steps that they can to prevent that impact. And what you saw here is something that the court found that Shell did have this duty of care to prevent impacts, negative climate impacts on human rights, as you mentioned, Tom, from climate change throughout their value chain. And so that they have an obligation, in fact, to prevent those impacts. You see also in not just in the international normative standards, which are again sort of these soft law standards, which are starting to be translated into hard law. This idea, this principle does exist throughout other forms of the legal system. If you think about child labor, there was a law passed in the Netherlands 3 years ago, in fact, that said that companies who sell products on the Dutch market that are made with child labor at any point in their supply chains, these companies have an obligation to make sure that child labor, that negative human rights impact is not happening. And if they cannot do that, if they cannot be sure that they are not using child labor in their supply chain, then they need to change their supply chain. They need to shift to another location or to another product that does not contain that child labor. So it is extensive in a sense. The scope is very broad, but it's really designed to address the increasingly high and severe impacts that corporations are having around the world, and to get at this idea of a shared responsibility for some of these negative impacts. It's not just the company right at the source that has a responsibility to address that impact, but it's throughout the supply chain, because there are many actors throughout the supply chain that are benefiting, that are profiting from that particular practice, for example. And so they all have an obligation, in fact, to use their leverage to try to address that impact and make sure that it doesn't happen.
Yeah, I think this is a really interesting point, because they have that responsibility, and the verdict stated that it's not an optional responsibility for companies. It applies everywhere, regardless of the local context, and it is not passive. So they need to they need to be proactive in this. But can judgments like these, can they overrule like local or national law?
Well, I would say that they cannot overrule national law. They should not. But I would also argue that is not necessarily what is happening here. And these soft law standards, they basically say the first obligation of companies is to abide by the local legal context, the local law. But in many cases, these normative expectations, these internationally agreed standards for good behavior, which are soft law at the moment, but are becoming increasingly hard law, they in many cases go beyond the law, the national law. And so what they would say then is, yes, abide by the local law, but if these international standards, if this duty of care that you have from your home country, let's say from the Netherlands in this case, if that expects you to adhere to a higher standard, to do more than even the local context is requiring you to do, then you are in fact expected to abide by that higher standard. The higher standard, let's say these judgments, they shouldn't force a company to breach a national law. They cannot encourage companies to break national laws, but as long as the company can stay within the jurisdiction of the local legal context, within the boundaries set by the local law, they do have this higher standard, this higher expectation. And I think that's what the Shell case is particularly saying, is that regardless of the minimum standards that companies have to abide by in the different national jurisdictions where they operate, there exists a higher duty of care, a higher expectation that they should apply when operating internationally.
Okay, so yes, that makes sense. But I think, as we know, I mean, national laws are perhaps easier to enforce. And so, of course, this is meaningful that there should be held a normative ruling. But will this really have any binding effect in that it's going to, I would imagine, it's difficult to enforce, and I don't think, well, maybe you can tell us, will countries then also, the governments of these countries then be responsible for trying to enforce this? How are working out?
Yes, you can say, I think the way that it is intended to work, or potentially going what the Dutch regulator, or let's say the Dutch judge, would in this case look to see if the company, Shell in this case, had executed that duty of care, whether Shell, it could determine whether or not Shell put the necessary effort, the necessary means, the necessary resources into doing what was considered reasonable in this case to prevent that impact. And so what the judge, let's say in many of these cases, may not do is go to the other country and say, well, this is the impact that happened on the ground, this is the human rights impact there. But they will really be looking at what happened in the Netherlands, sort of the decision-making processes and the policies that were set up and the processes that are put into place within the Netherlands, within the home country, the headquarters, and see, was that sufficient? Was that adequate to address the risks that are there? And that's what I think that they will really be looking at. And obviously, there needs to be with civil liability, there needs and the right to remedy for impacts for the victims of certain impacts. They will need to have this pathway to justice, actually, from a citizen or from a victim of a human rights abuse in a faraway country, to be able to file a complaint, to alert the Dutch judge or to alert the Dutch let's say regulator that a particular impact has taken place, and then the judge or the regulator will start looking at whether or not, again, this duty of care was fulfilled.
Mm-hmm. So maybe just for my own clarification, but how do you determine what is reasonable and what is not reasonable? Because I feel that might be a tricky thing to determine, where a company might say, yeah, we did everything that we could, but some things we simply can't influence, and other parties might say, well, naturally you should have done more, or you should have been more proactive.
Yeah, that's right. And that's where in the Shell case that we're discussing, the judge really looked to the normative standards again, because the OECD guidelines, for example, and the UN guiding principles are in fact quite detailed. And there are some elaborations. There are the guidelines, let's say the normative standards, the law themselves. And then these international bodies, OECD and UN, have developed quite detailed guidances for how to interpret the reasonableness, which steps. There are some process-oriented steps. The OECD, for example, lays out 6 steps that companies should take to meet this requirement of doing due diligence, or doing their fulfilling their duty of care. So they lay out 6 different quite detailed steps, from beginning with processes and policies and decision-making procedures within the company, then talking about did you do a reasonable identification of the risks that were out there? Did you consult with people? Then did you take any particular steps to try to mitigate or prevent those impacts? Did you track your progress on implementing the steps that you've taken? Have you communicated about it? It's also a very important part of this duty of care, is communicating with the public and with also impacted rights holders about the steps you're taking. And finally, if an impact does occur, you have the responsibility to remedy that, to provide compensation or other forms of remedy that might be in question. So the reasonableness, it is always going to be, it's an open norm. Let's say it's an open standard, and that's acceptable, or that's relevant, and that's for both hard law and soft law. But there's always going to be a little bit of this element of that a company, in first case itself, is going to need to make a judgment about what's reasonable for us in this case. And then if that does lead to an impact, or if a stakeholder, an NGO or a union or the public finds that was not reasonable, what the company did, that the means were not sufficient really to address the impact at hand, they can file a complaint. And then the judge or the regulator will have to evaluate that himself or herself. So there will always be a little bit of a gray area or some wiggle room, but it really is the case that there is quite a bit of detailed guidance from that are sort of accompanying these standards.
Yeah,
the judges can look to.
And I think this leads very nicely into the objectives and the requirements of companies, because as you said, they're quite detailed and they're outlined. And I think what is interesting about this lawsuit, it speaks to perhaps further requirements for businesses to take certain aspects into consideration. So it shows that financial objectives from companies cannot prevail over the obligation to, for example, respect human rights. You spoke about it in, for example, the child labor, but the human rights, the climate and the environment. Do you think that we'll see big businesses becoming more social businesses?
Yeah, I think it's a great question. And yeah, one thing that I thought was particularly brilliant in the statement by the judge, the verdict in this case, was that she said, what we are very clearly saying with this judgment is that the company's financial objectives may not prevail over some of these other larger social standards and norms, human rights and the environments. And that has really, obviously, going back to the Milton Friedman and the business of business is business back in the United States in the 1960s, 50s, and 60s. And that sort of narrative, that paradigm is really shifting now. It is no longer acceptable to say businesses only have the objective of generating return on interest or return on investment for their shareholders. They have other obligations with regard to human rights and climate and the environment. I don't think that businesses will do this by themselves. And so in a way, I wouldn't say, I think most businesses are going to continue to be focused on profit maximization. And they are going to be continuing to focus on, within the framework, the legal framework, the normative framework that is provided to them by legislators, lawmakers, governments, and society, I guess, they will always search for the maximum profit within that framework. So I don't think we can expect them. There are some social businesses out there, obviously, that really have these dual objectives and dual goals. They are in general the smaller ones, and sort of more like the pilots, and clearly have separate objectives. And I think that most big businesses will continue to push as far as they can on the profit side. So it's really up to the regulators, I think, and up to the lawmakers to make sure that the framework, the legal framework within which the businesses operate is clear.
There's actually one example that I'd like. You spoke about this briefly just before we got into the interview. You said companies may not make the decision to bring more environmental shareholders into the company because they feel that it's a worthwhile investment, but it may prevent future lawsuits, and they may say, okay, we need those people. So I was wondering if you could briefly, reiterate or remake that point, because I thought it was a really interesting perspective.
Yeah, sure. You see, I think, really also an increasing trend towards shareholders, so basically the owners of big businesses, who are increasingly seeing human rights violations and climate violations as a risk, a financial risk to the business, because if you look at the number of lawsuits, if the Shell lawsuit, if there are others, and Shell is maybe one of the first ones, but there are dozens of other lawsuits in the United States that are pending right now. And I think, given the ruling here in the Netherlands, depending on how the appeal goes, we're going to see really in the coming years an explosion of legal cases against companies related to impacts like this. And there are some new laws also being developed. In France, there is already a supply chain responsibility law. In Germany, just about 2 weeks ago, there was a new law passed related to holding corporations accountable for negative impacts in their supply chains. And in the Netherlands right now, too, there's a bill in Parliament that's being discussed. So the legal framework and the judicial framework around some of these companies is becoming increasingly, let's say, clear or tight around them. And shareholders are seeing this, and shareholders and investors in these companies are seeing this happen and recognizing that if the company that they invest in, that they own, is going to be on the hook, is going to be liable for impacts on the climate, and lawsuits are going to be possible, that is a real financial risk. And so in the same way, that they have paid attention in the past to, whether the company's making the right investments from a market perspective, or choosing the right products to produce or services to provide, investors are going to increasingly look at the climates and the environmental and the economic liabilities that companies might be getting into, and then purely from an economic self-interest, financial self-interest, are going to push the companies to become more sustainable, let's say, responsible.
I mean, maybe this is a move also towards more stakeholder capitalism rather than the pure, perhaps, Friedman form that you mentioned before. And this might not be a bad thing.
No, I say this is exactly one of the biggest problems, or one of the biggest sources of many of the different problems that we're facing in the world now, from climate to even some of the economic problems, like the financial crisis from 2008, that had such a devastating impact on so many people around the world, and has exacerbated inequality, to climate and human rights problems. Many of these have their origin in the shareholder capitalism and the focus on short-term profit maximization. That if we can start to change that, and I think the only way to really do that, to start to change that, is for governments to start acting and putting rules and creating the possibility for these legal actions against companies. If we can start to do that, we will change the model from the shareholder profit maximization model to this more stakeholder, more broader environmental impact, environmental interests, and human rights impacts also being incorporated in the company's basically bottom line. And that's really what it's about too. It's about internalizing those costs, which are now so effectively externalized by companies, and put on societies, the burden on societies, and bringing those costs into the balance sheet. And investors are going to see that and start acting. So I'm really hoping, the idea is through this, you get to a virtuous circle, a better
world.
Yes.
Okay. Maybe we can just move on a little, but it's in the same, we're still in the same ballpark here, because we want to talk also a little bit about this notion of a global minimum tax. This has been raised quite recently by the G7 countries. I think also Joe Biden has spearheaded that quite prominently. Now, according to the OECD, countries around the world lose out on an estimated $100 billion per year in tax revenue because of these profit shifting maneuvers. Some critics say that a global minimum tax could be helpful for leveling the playing field. Others have said, though, that it could hinder cross-border investments and it could slow foreign direct investment globally. Now, if we look at a country like the Netherlands or like Ireland, for example, some might see them as tax havens. Others might say that they are investment hubs. So our question for you, Joseph, is how will a global minimum tax affect a country like the Netherlands, and how do we find a compromise between these two quite different ways of seeing this problem?
Yeah, that's a very good and very complex question, of course, too. And I guess I would first say that this idea that the global minimum tax would hinder cross-border investments, I don't really see how that would happen. Because it's exactly doing that is creating sort of a level playing field, with the idea to actually incentivize more cross-border investments. on a more equal, let's say, or equally distributed rate around the world. What you have now is really an unlevel playing field where you have, because some countries have, a much higher minimum tax rate for corporations, and others like the Netherlands and the tax havens a much lower rate. You get sort of a really perverse effect where between certain countries, you're really minimizing the cross-border investment because the investment is not going between those two countries anymore, but it's all coming through countries like the Netherlands and Luxembourg before then going back out. So I don't think it would, I don't see how it would necessarily hinder real cross-border investment. What I do think, and there was an interesting report by the IMF recently about phantom investments, so the rise of phantom investments, phantom FDI, where I think a global minimum tax rate would have an impact on that. And what that is, these phantom investments is basically just sort of money flows that are flying around the world and being calculated, being in the statistics for FDI, even though they're not really being put to any actual concrete purpose to build a factory or to invest in. It's just it's all sort of on the books, fake phantom investments, which is all being done, of course, in order to reduce corporations' tax, evade taxes, reduce their tax burdens. And so I do think that you would see quite a significant effect on that. So maybe if you're just looking at the total FDI statistics or investment statistics, you would probably see a pretty significant drop in that sort. But those are not the kind of flows that you want anyway, because they're not generating anything for society.
But I mean,
they're just
I do think there's an issue though. Well, I also saw somewhere that the African Tax Administration Forum, for example, they've argued for a tiered approach to corporate taxation for smaller countries, because allowing for these different tax liability thresholds, which would help, I think, small economies. I mean, the Netherlands is a small economy, although it's obviously a very wealthy country, but I think we can see that there will be some potential fallout from something like that. So maybe it is a case of, as they say, God is in the details. It's going to be a case of how well can they structure this minimum corporate tax? How thoughtful can they be in its implementation?
That's right. Yeah, and I think there's definitely something to that. And I think that if you look at what the OECD has proposed, they've got the BEPS project. It's called Base Erosion and Profit Shifting. It is really looking at, and one of the pillars of that project is this try to harmonize the global minimum tax rates, just to get more of a level playing field. But the other pillar of that is also very important, and that is really looking at making sure that the taxes and the revenues, the profits generated by certain industrial activities or economic activities really stay with the country. That's the base, avoiding this base erosion. So keeping the tax there where the activity is taking place. And I think that is certainly the case for many of the sort of traditional or old school, really industrial activities. That is going to be key. The interesting area, and I think maybe, or in fact, what the minimum tax rate too is perhaps more focused on, and that's going to be big in the future, the technology sector, and some of these giant companies like Facebook and Apple and Amazon that themselves, they don't really themselves obviously have much sort of industrial presence in generating activity in one country. They exist in the cloud. They don't have a particular, a heavy industrial presence anywhere. And so those are the companies, and obviously they are, some of the richest companies in the world. Those are the companies that you would need to have, or you could argue, the proponents argue that you need to have this global minimum tax rate to approach.
Wow. Yeah, I think it's no, but it's a highly complex topic, and I think
It is.
you've managed to give some very good and concrete examples. I think rounding up, specifically looking at both the topics that we spoke about, so speaking about like the framework and the monitoring, the responsibility, the tax rates, I think one of the key questions that is still on our minds is that well, we know Shell is going to appeal, and depending on how the defense goes, that the government might change laws, and that we hope that the framework gets changed. But bringing it back to the individual citizens, where does that leave us? So will we see more of these sort of spearheaded civil activist groups against large corporations, or maybe even what could we as concerned citizens do?
Yeah, I think that's the key for going forward is to, well, I'm always hesitant about putting too much of the burden on the consumers and on, let's say, individual citizens, because I think that there are again, there are certain rules of the game that governments are really responsible for setting and making sure that corporations operate within that certain framework. And but once you have that, if you have that framework, that legal framework, there is certainly a big role for individuals. And you saw that with the Shell case, that was led by some civil society organizations, which is, of course, also sort of just engaged citizens, but they are professional civil society organizations. But the case was also signed on to, supported by, several thousand individual Dutch citizens. So I think that type of cases, that sort of collective action type cases, are going to be increasing in the years ahead. And I think, especially if we have the supply chain laws which are coming up, you really will see possibilities for individual citizens to get involved in cases like this. And those normative standards that we started out with, the OECD guidelines and the UN guiding principles, which are soft law being translated into hard law, they are very clear too that individuals can file complaints against companies, can raise these types of issues with companies. It doesn't have to be, you don't have to be a lawyer, you don't have to be a professional organization. Individual citizens or individual groups of citizens acting together really can have a role here and have an impact. So I think that we're going to be seeing more of these going forward.
And I mean, I think in that sense, it's all of our responsibility to be informed as individual citizens, because it does seem to me like the landscape is changing quite quickly and quite significantly.
Definitely. Yeah, this is a very exciting field. I think, I've been in this field for, I was saying about 17 years, and I've seen things are moving more quickly now in the last just 2 or 3 years on this front than they have in the 15 years before that. So I think it's a really exciting area to be thinking in, and indeed for people to be considering not only their own responsibility in terms of consumption, but really what other options they have to address some of these issues.
You are a one to watch, Joseph, in this field especially, that is ever changing, and there's much to look forward to. I am conscious of time, and I'm worried that time always flies when we're having these fascinating conversations, and I'm sure
there's fun.
Yeah, I was gonna say I'm sure that there's much more that we could talk about, and that there's much more nuance that can be added to this discussion. But for now, I just want to say thank you so much for joining us today and for sharing your viewpoints.
Thanks to both of you too for highlighting this topic and for spending some time on it on the air.
Yeah, thank you, Joseph.
Absolutely, and for our listeners, you can find out more information on this topic also on the website at www.somo.nl.
Right, so stay tuned for another episode at the same time next week. In the meantime, please follow us on Instagram, Facebook, or Anchor. You can find all of our previous episodes there. Most recently, we also did an episode on what we call rainbow sports. So if this is a topic that interests you, check it out. Remember too that you can also watch the full unedited interview on our YouTube channel, also called Stork Talks. So thank you for stalking with us again this week, and we look forward to welcoming you back in the future.